The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the state of North Carolina. Oyez, oyez, oyez. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you. Good morning, everyone, and welcome to the Court of Appeals by WebEx. We're glad that we're able to hold court in this manner for you today. The panel today, I'm the head of the panel, Chief Judge Donna Stroud. To my virtual right, we have Judge John Airwood. To my virtual left, we have Judge Darren Jackson. That's how we would be situated in the courtroom. So anyway, we have one case for argument this morning, Thomson versus Union County, and I believe our attorneys are all ready to proceed. So I believe you had already determined as far as the timer, if you want 5 minutes for rebuttal, that's what it's already set for. If you want anything any different, let us know. And unless you have any other questions, we're ready to proceed with the appellate.
Thank you and good morning. May it please the court. I'm Geraldine Sumter with Ferguson Chambers Sumter in Charlotte. We represent the Thomsons in this matter. Today, this case presents for you a question of interpreting the application of the Unified Development Ordinance for Monroe, for Union County. The facts are fairly simple. The property in question sits on Stinson-Hardis Road, which runs on the front of the property, and there is a private side street which runs on the side of the property. This property was built in 2004. Union County issued permits for building and for occupancy. It was used as a private residence and continued to be used as a private residence through the time that my clients purchased it. In 2009, a large garage was built. A building permit was issued, an inspection was done, utilities were approved. On this property, there are actually two buildings that might be referred to as garages, but there is really only one garage that's in question, and we'll refer to it as the large garage or the garage. The property remained in the ownership of the original builder from 2014 through 2013 when it was purchased by some Kellers. In 2018, Ms. Keller put the property up for sale. And around the time that she did that, Union County gave her notice of a violation of the Union County Unified Development Ordinance. After that notice was issued, the plaintiffs purchased the house on June 20th, 2018. After they purchased the house on September 6, 2018, another notice of violation was sent to the plaintiffs. They sought to appeal that and were successful in getting heard before the Union County Board of Adjusters. The first hearing before the Union County Board of Adjusters was in February, on February 11, 2019. It was adjourned and continued on May 13, 2019, at which point, and in both of these hearings, testimony was taken, questions posed and answered to the best of folks' abilities. Documents were submitted. On May 28, 2019, the Union County Board of Adjusters affirmed the administrator's determination of a violation. The plaintiffs appealed that decision to the Union County Superior Court, and Judge Hunter Gwynn heard the case on March 2nd, 2020, and again held a final hearing on October 26, 2020, from which he issued an order and from which the plaintiffs appealed to this court. Now, the plaintiffs' arguments are as follows. Number one, we believe that this case presented issues that should be reviewed de novo and under the whole record test. And in fact, Judge Wynn states so in his order that he was reviewing some issues based on the sufficiency of the evidence, which should have the whole record test applied, and that he viewed the petitioner's complaint that the appropriate ordinance, the ordinance applied was inappropriately applied, and as a result amounted to a constitutional violation. And on that, he acknowledged that he should do a de novo review. However, there are no findings that show us what the judge's findings were to determine that there was in fact a violation. What we have is merely an acceptance of the decision made by the Board of Adjustments. And for that reason, we believe that this court should remand this matter back to, if you find that the statute in question was applicable, you should remand it to the court to make appropriate findings. Now, our second and perhaps prominent argument among the arguments we make is that the Unified Development Ordinance should not be applied in this case. And we say that because the ordinance was effected in 2014. The property was built in 2004 with permission from Union County. It was inspected and a final and permanent occupancy order was issued. This house sits on a highway that Union County officials travel. They had maps of, Google Maps of, they had knowledge of any violation that they now say occurred back in 2004 through the time that they finally issued this notice of a violation. Now, the county says that it has a duty to maintain certain safety standards and development standards. However, the county did nothing about this property until the former property owner's real estate agent asked a question about it. If that real estate agent had not asked a question about it, we probably would not be here because the county was not uniformly and effectively enforcing its own policy.
Now, Ms. Sumter, the county had already at that point the county had issued building permits for both of these buildings, isn't that correct?
Yes, Your Honor.
And they issued a occupancy for the house.
Correct.
And they also approved the wiring and construction and all of that of the garage.
Correct.
And they did all of that by 2009.
Correct. The house in 2004 and that garage that's in question in 2009. But no notice of any violation until June of 2018, some 9 years later. So before the Union County Unified Development Ordinance went into effect, there was, of course, a land use ordinance. The ordinance in question provides that if there is a building, development, or structure for which a building permit was issued before the effective date in section 1.030 may be completed in conformance with the issued building permit, even if such building development or structure does not comply with the ordinance, that you would not impose the standards of the ordinance. Now, the ordinance applies, it appears, to buildings that are under construction or were under construction when the ordinance went into effect, or were completed and did not comply. So in essence, that provision is like a grandfathering clause. Without it explicitly saying grandfathering, it effectively means that it's a grandfathering clause. Now, I read the appellee's brief, which said that only applied, the ordinance would only grant an exemption, if you will, if there was an unfinished building when the ordinance went into effect, that building could be exempt, but buildings that were already built years before would not get the same consideration. And so for that reason, we believe that this property should be exempt from the application of the current Union County UDO, and because if there's a violation, whatever violations the county claims existed from the beginning in 2004, 14 years they had allowed this building to exist and took no action. And the interesting thing is, in 2009, when they issued the permits for the garage, they had to see or become aware of that big house that was there since 2004. So they knew or should have known back in 2009 that there was a problem. If they hadn't done anything else, they could have made, given some notice back then, but they didn't. Now, I'm sorry, Your Honor.
Excuse me for interrupting you. Just one other question. Was there any predecessor to the UDO in Union County?
Your Honor, there was something called I think it was called the Land Use Ordinance, the LUO. And in the record, there is some discussion about similar setback requirements back then. But, and I believe that ordinance went into effect in either 1998 or 1999. But the county still issued the building permits in 2004. Now, what we have here is a statute, if applied, in this sense, retroactively to that 2004 construction and the 2009 construction, would interfere with vested interest and right that the plaintiffs have in this property. They never received specific notice of the setback issues until they received the first notice of the violation in September, almost 3 months after they purchased the property. That being the case, we don't believe that justice or equity or the construction of the statute should result in this decision by the Board of Adjustment being affirmed. We believe that it is too late under the Statute of Limitations for the county to now bring this action. We believe that the statutes in effect either give a 5-year or a 7-year date for enforcement. Neither of those dates have been met by the issuance of the 2018 ordinance, notice of violation of the ordinance, and for that reason should be denied. Now, I will be frank with you, the lay people who represented themselves at the Board of Adjustment hearing did not raise the statute of limitations issue. But when she had counsel, when she first had counsel, she did raise that issue, and she raised it in the Superior Court. So I believe that that issue is properly before you. Even if the decision by the Superior Court, if you find that it did not have to have specific findings of fact, we do take issue with some of the findings of fact made by the Board of Adjustment. Their finding of fact number 8 states that at the time that Thomson purchased the Thomson residence, she was aware of both violations of the side yard setbacks. First, throughout the hearing, whenever she was questioned about what she knew, she responded by saying at some point she knew, or she had been told, that the garage did not have a permit. She never said to them, I knew that there was a problem with the setback. She knew that there was a problem, or somebody had told her that there might have been a problem with the garage having a permit issued. But the record established that there was a permit issue. Even Mr. King acknowledged at some point in his testimony at the first hearing that when they went through the records, they did find a permit issued in 2009. So to make the assessment that this ordinance should apply, or that the violation should be charged to the Thomsons based on some supposed knowledge that she had of the setbacks, would be wrong. And further, her knowledge of, or lack of knowledge of, the setback is not a consideration at the issue on whether there was a setback or not. The question is there a violation or is it not? Now, whether she knew about the violation or had been given notice of the violation by the previous seller may be relevant information in a cause of action that she might have against that seller, but it's not an issue for the board. Now, and I'll rest on the rest of the brief on the other violations or the findings of fact, but our argument is that you should find that under applicable law, it is inappropriate to apply these setback provisions to this property in light of the facts in this case. And I thank you, and I'll rest on the brief on the rest for the rest of the issues.
All right. Thank you. And Applee, you can proceed.
Good morning, Your Honors. May it please the court. My name is Ashley McBride, and I'm here on behalf of the Union County in this matter. Your Honors, as appellant stated, this is an appeal from an order of the Superior Court of Union County, which affirmed in all respects in order of the Board of Adjustment, which found that the home and the garage at issue in this case were in violation of Union County setback requirements.
Now, Ms. McBride, if your client prevails, are they able to then go back and make these folks tear these buildings down?
Your
Isn't
Honor,
that your real position here?
yes, Your Honor. Unfortunately, that is the position.
And
There was some
isn't it true,
discussion.
ma'am, that the last time anything was built on this was 2009?
Yes, Your Honor, that is the case.
And that was built with permits issued by your client. Is that correct?
Your Honor, the appellants have stated in their brief and in this court today affirmatively that permits were issued. That has not been substantial.
Didn't your client agent admit to that during the hearing that he found a permit?
No, Your Honor. He never admitted he found the permit. What he admitted was that there was no evidence. So the Union County permits are purged after 6 years. What he stated was, we have not cited them for lack of a permit. So at this point, we're not pushing the permit issue.
Is there a requirement for a building permit for a house to be built in Union County?
There should be a permit, yes.
And are you contending there wasn't one built here?
Your Honor, there's no evidence that a permit was issued. What there is evidence of, at least 8 times in the record, Ms. Thomson claimed she was told there was no permit. There was a lot of discussion in both Board of Adjustment hearings about whether there was a permit or whether there was not a permit. There was no finding of fact on that. There was not conclusive evidence. And again, what the county actually testified to was that we have not cited them for not having a permit. But Your Honor, I would contend that whether there's a permit in this case is frankly irrelevant.
So, Ms. McBride, you said something about permits are purged after 6 years. What does that mean?
The county doesn't keep records past 6 years. They purge everything.
So you're saying that any house that was built more than 6 years before, an owner of the house would not be able to go and prove that there was a permit. So then the county could come in and say about a house that was built 40 years ago, you're in violation of the UDO, and we want to tear your house down?
No, Your Honor, because permits are purged, yes. The owner could keep the permit. I'm not saying that they're required to do that. But here the issue is not that there was a permit. The issue is that it's in violation. A building permit is obtained at the beginning of the process. So if in fact a permit was obtained for this garage, what that permit would do was say you can build it on this property per the plans. You can, this is a R20 zone, so it's a residentially zoned area. So they could build, a garage, they could build a home, they couldn't build a hotel. But what a permit does, and what I think that the appellants are misunderstanding in this case, a permit isn't a final stamp of approval on the home. A permit is to say, yes, you build it, and then a permit, you build it in accordance with applicable zoning and local ordinances. If you get the argument that because they had a permit, they can never be in violation, it can lend absurd results that you got a permit before you started anything, before you put anything on the ground, which is the permit is the first step of the building process.
Ms. McBride, I don't think the argument is that if you have a permit, you can never be in violation. But I'm trying to understand how we can apply setbacks from a 2014 UDO to a house that was completed in 2004 and a garage that was completed in 2009. How does that happen?
Your Honor,
and would this apply to houses built in 1930? I mean,
yes,
how far back does it go?
Yes. So the first ordinance, there's some testimony in the Board of Adjustments that the first ordinance in Union County was enacted in 1978. At the time that this home was built, the LUO was in place. The setback requirements of that LUO were the same that they are of the UDO. As I stated in my brief, Your Honor, there is case law on this exact issue. In Overton versus Camden County, this court specifically held that the zoning ordinance in effect at the time of the Board of Adjustments decision is the correct ordinance to apply. So case law, Your Honor, the case law supports the notion that this is the ordinance we would apply. Again, that was Overton, Camden County. That is the specific holding of that place. Again, the zoning ordinance in effect at the time of the Board of Adjustment's decision is the correct ordinance to apply.
So now, it's your argument, as I understand your argument here, Ms. McBride, it's your argument is if we come in, if Union County came in today and said the setback should be 50 feet from the road, anything that was not 50 feet from the road would then be in violation, and you could violate and tear that down. Is that the county's argument?
Your Honor, not exactly. So here, Ms. Sumter mentioned briefly a grandfather provision. There was testimony at the Board of Adjustments about grandfathering, but for something to be grandfathered, it had to be legal to begin with. The appellants have offered no evidence that this was ever legal to begin with.
If there was a permit issued and a certificate of occupancy issued, wouldn't that make it legal to begin with?
No, Your Honor, because again, a permit comes at the beginning, and a permit.
What about a certificate of occupancy?
Well, let's say there's been zero evidence that a certificate of occupancy was issued for the garage.
What about the house?
There hasn't been evidence of that either.
You don't have to have a certificate of occupancy to have a house in Union County.
You do, Your Honor, but the certificate.
Not since at least 2004.
I'm sorry?
And have you not had since at least 2004?
So, Your Honor, I think there's a fact in this case that has not been yet discussed that I think is important to note. The reason that this
Please
issue.
answer my first question before you move on to something else.
I apologize, Your Honor. What was your.
Did you not have to have a certificate of occupancy for a house in 2004 in Union County?
There should have been a certificate of occupancy, yes. But a certificate of occupancy doesn't confirm that it's applicable zoning. Inspections that are done on a property, and you can see the record that was submitted, those are electrical. That's not zoning. The only way to know that a zoning violation has occurred when it is this situation where there is an issue with the boundary line would be a survey. Certainly a survey before anything was built, which is what would be submitted to get a permit, wouldn't have the final built project on it. So in this case, the reason that it came up, and again, the fact I think that's being missed is that when Ms. Keller, who was the prior owner of the property, when she went to sell the house, she went under contract with a first purchaser. That purchaser's lender, as is pretty standard, required that purchaser to have a survey done. That was the first survey, as anyone is aware, that was done once the home and the garage were built. That survey is what showed the encroachment. That survey, Your Honors, is throughout the record on, excuse me, on multiple places. 74 is one. But that survey showed there was an encroachment of the garage. Not only was the garage within the setback, the garage was actually within the right-of-way. So as Ms. Sumter said, this home is on Stinson-Hardis Road, and then there are 4 homes serviced by a private gravel drive built in a right-of-way. So the garage, the survey showed that the garage was actually within the right-of-way, not just within the setback. So at that point, that is when the county first could have known about the setback issue, because that was the first time there was a meets and bounds description, the first time that there was a physical way you could look and tell that it was an encroachment. Again, there's been a lot of discussion about the permit, but the permit comes before anything is built. So just because the county issues a permit and says you can build this, in accordance with the permit, doesn't mean that the owner and the builder can then go and set the house over the property line. That's not the function of a permit, Your Honors. So when this all came up was in April of 2018, when the first buyer backed out because of this survey, because they couldn't get good title. Excuse me, Your Honors. The first buyer backed out. There was then, it was relisted. If you look at page, I believe it's 92 of the record, 91 of the record, Your Honor, that is the MLS listing. And it shows right there, it says, let me turn to that so I can read it exactly for you. It states that this home is listed $133,000 below appraised value. See appraisal. Cash offers only. House is encroaching on private drive beside house. Being sold as is. So that survey is what everyone then knew of the issue. That survey was presented to the county with the hopes that it could be, there was some corrective actions that could be taken. Your Honors, if you can tell by the Board of Adjustment, especially the first transcript, there was members from the county there and members from the neighborhood. The county did everything they could to try and bring this in compliance. Because I think one thing that has been misunderstood is Ms. Thompson at the Board of Adjustment kept mentioning a variance. She wanted a variance. A variance is not even applicable in this case because that garage is within the right-of-way. The right-of-way is the adjoining property owner's property interest as well. So they would have had to first agree to shorten the right-of-way, is a 60-foot right-of-way, to a 30-foot, and then the county could have potentially granted a variance to bring it in compliance. So, you know, I can understand the concern here is that they're going to come in and make this couple tear down part of the garage. The county has tried everything they can do to not have that happen.
You've also said that they could make them tear down the house too, right?
They could make them tear down the parts of the house, but the house is much easier, Your Honor, to bring in compliance because the house is it's just over the setback as shown on that survey. And if I'm going to share, if y'all are okay, I'm going to share the survey on the screen so I can point it out to you. I did notice when I when I looked at the uploaded record, the survey on the Court of Appeal site is a bit fuzzy. This is the exact same survey. It's clear. So this is a survey here. Can everyone see that?
No,
Oh, okay, sorry. What about now?
I think it's going there. There we go. Yes, very good.
Okay, so this is a survey that again was done in January of 2018. And again, this is the survey that showed the issues. So right here, you'll see where I'm kind of hovering. That is the garage. So this dotted line right here, that is the old 60-foot right-of-way. So you can see right there, the garage not only is within the setback, the garage is sitting within the right-of-way. So yes, the garage is going to be much more difficult to bring into compliance. There's some testimony about they'd have to shorten the roof and certain things would have to be done and remove certain parts of the garage. They don't have to tear down the whole garage. They have to bring it in compliance. This is the home right here. If you see right there, it says C inset B. So again, this right here, this line, that's the old right-of-way, okay? Or it's the current right-of-way. They were trying to change it to help them. If you go to inset B, this is where it does show the house is 105 square foot over the setback line. And then it shows also right here, this part right here, see inset C. Again, that little part of the house right there is over the setback. And again, this is the right-of-way. You can see from this drawing that the county was trying to assist by showing the old right-of-way, and then they proposed a new right-of-way. But again, it would have been up to the neighboring owners to shorten that right-of-way. That didn't happen for whatever reason, you know. I don't know what that reason was. But that is the issue. So yes, it does seem harsh that she may have to tear down a portion of that garage. Again, we have tried to get it into compliance. But I want to point out also that one of the facts that has been discussed is that she didn't know. Your Honor, Your Honors, the MLS stated it. The deed took it to applicable zoning. She knew she had to pay cash because it was encroaching. There was testimony that both realtors, the Thompson's realtor and the seller's realtor, met with the zoning administrator before this happened. So she took this property well aware that there was an encroachment. She got
If I could ask, so, yes, there's certainly evidence that she was aware of it. It was in the listing. Does it matter? Does it legally matter whether she knew or not for purposes of this case?
No, Your Honor, it doesn't. Frankly, legally, it doesn't matter. Knowledge is not a requirement. The fact is that it's within the right of way. The fact is that according to Overton versus Camden County, the zoning ordinance is the proper ordinance to apply. Your Honors, appellants have cited section 1120A1 to again argue because a building permit was issued, then this house, doesn't violate the UDO. Again, case law shows that the UDO is the proper standard to apply. My argument, I stated in the brief, if you read section 1120, the tense of the language, it states that the home may be completed. So it's envisioning that the home is not yet completed. The building permit was issued, but the home is not completed. They can then complete in compliance. Ms. Sumter briefly mentioned grandfathering. Again, to grandfather, you would have to show that it was legal when done. There's been no evidence it was legal when done. I think it's important to note, Your Honors, not one time before the Board of Adjustment, before 2 hearings, did the Thompsons ever even say that it was not in violation. Instead, they showed up and said it's not fair, it's not just. Ms. Thompson even apologized to the board the second hearing and said, I'm sorry if I've wasted your time. I now understand the issue is whether there's a violation. There is a violation. The record shows there is a violation. Your Honor, appellants next contend that it's impermissibly retroactive. Again, Your Honors, to prove it was impermissibly retroactive, it has to be proved that it's altering the legal consequences of action performed before the statute. Again, it was illegal when it was done. The Thompsons have offered no proof that this was legal when they built it. So that would be our argument of why the UDO is applicable, Your Honor. Briefly, I will touch on the Rule 52 argument.
Well, let me, Ms. McBride, did the violation charge that this was, was there a claim that it was in violation of the LUO, the previous ordinance? Or
No,
was it only
it
under
was
the new?
enacted under the UDO. The violation was under the UDO, and that's you apply the UDO at the time that the enforcement is taken. If then that person can prove it was legal prior, then they could have it grandfathered as a legal non-conforming property. That never happened here. Your Honor, I briefly would like to just touch on the Rule 52. Rule 52 here is inapplicable for a number of reasons. First and foremost, this was not an action tried upon the facts. This was an action in the nature of certiorari. The appellate court, the Superior Court was sitting as an appellate court. So findings of fact were not necessary. There has been clear case law, Myers Park Homeowners Association versus the City of Charlotte. The exact same situation as here. It was a zoning board, a appeal from a zoning board. The Superior Court affirmed that zoning board's order. They found that Rule 52 is inapplicable in these cases. So in this case, Your Honor, we would argue Rule 52 is inapplicable. Appellant's third argument is about the statute of limitations. There are a number of reasons. We argue there are 4 reasons that the statute of limitation argument fails. First and foremost, there has been no action by Union County per statute that would count as enforcement under the statute of limitations. Action is defined in general statute.
So you're contending, you want us to find that fining someone for a violation is not an action under the statute? Is that your argument?
That is my argument, Your Honor. Action is defined in section 1(2) as an ordinary proceeding in a court of justice by which a party prosecutes another party for the enforcement or protection of a right, the redress of a wrong, or the punishment or prevention of a public offense. So the way that zoning violation,
So finding someone $50 is not punishing them?
it's not an action in a court of justice per the statute, Your Honor. Statute of limitations apply when someone files.
So how is this not an action in the court of justice? Does that statute say, it doesn't say who it has to be brought by?
You mean the action statute or the statute of limitations?
The one you were just reading?
No, that just defines an action.
Okay.
So the way a zoning violation works is you notice the violation. If they appeal, then you go through the appeal and you can go through this whole process. But if there's no appeal, what would happen is if the property owner doesn't come in compliance, then that's when the action would be filed. So that, Your Honor, that would be our argument that action has never been filed. There's never been any enforcement of the violation.
Okay, so Ms. McBride, let me get it. So let's say, hypothetically, let's say Union County were to win on appeal.
Yes, ma'am.
And they don't do anything with the house. And then Union County brings an action to enforce, then they could plead the statute of limitations and say, whoa, way overdue.
Your Honor, I do think that's the argument. I'm not saying that makes great sense, but that's the legislative, I mean, that's what a statute of limitations is. It's an act, it's stopping the court action. Even if you think that this in and of itself is action, it's important to point out, Your Honors, the statute of limitation, both statutes 149 and 151 did not go into effect until October 1st, 2018. The first violation issued was June 1st, 2018. That violation was issued against the Kellers. The first violation issued against the Thompsons was September 6, 2018. So even if you find that this is an action, and clearly the appellants, that's their argument that this is an action, the statute of limitations didn't apply yet. Prior to North Carolina General Statute 149 and 151, there was no statute of limitations against the government. The concept was that you can't, defeat the government by continually violating the law.
It also then, but says that facts constituting a violation are known to a body and agents or an employee of a local government unit, or violation can be determined from the public record, which goes back to all of my questions about these permits that you said are irrelevant. But that's why I'm asking these questions about permits, because if your client is issuing permits, does that not make the action known to your client?
No, Your Honor, it does not. Again, because the permit is issued at the onset of the project. So the first thing you have to do.
Certificate of occupancy.
A certificate of occupancy is not saying that the zoning is correct. A certificate.
Your client had to go out and inspect the property in order to issue a certificate of occupancy, didn't it?
It wouldn't have been zoning, that would have been electrical or building.
But your client, an agent of your client, was there on the property to issue a permit, a certificate of occupancy.
Yes, Your Honor. If one was issued, someone was there. Again, our argument is that you can't tell you cannot tell where a building line is. If it's not marked, you can't tell where the proper boundary line is.
Mr. McBride, this is Judge Jackson. In order to get a building permit, don't you have to do a site drawing where you propose to build the house in order to get a building permit or an environmental permit?
You have to you have to submit plans, yes, and a site plan.
And then that site plan, when the foundation is poured on the property, that would be inspected by someone from the county, correct? And they would look at the site plan and decide, did they in fact build the house where they said they were going to build it, or did they build it in the middle of a septic field?
Yes, but again, without a survey, there's no markings for the boundary lines.
Is it your contention that in order for your client to have been on notice to this, it's not Union County. It's not any of the permitting offices of Union County. It's no employees, but it's actually the zoning department has to have notice in order for this statute to start to run. Is that your argument? Because I mean, like Judge Underwood said, there's a lot of building inspectors that would have gone out to this house during the building of this house and inspected it that are employed by Union County.
Your Honor, I'm not going to make that argument. Again, my argument is that when a building inspector or an electrical inspector or, a septic inspector goes out, they don't know the boundary lines. The boundary lines were never apparent until April of 2018 when the survey was submitted. So the home could have never been known to be in the setback without the survey. If you do choose to apply the statute of limitations, which we would argue is inapplicable for the two reasons I stated, as well as it was not pled. There was not one mention of the statute of limitations before the Board of Adjustment. There was not a mention of any statute by the appellants. But we would say even given those facts, it still has not run because it would have never started to run under the 5-year or the 7-year until that survey was submitted to Union County. So that was in April of 2018. The 5-year statute of limitations, it's 5 years from the date the facts were known to the governing body, or it's 5 years from the time it could be determined by the public record. So the appellants have argued in their brief that aerial photos on the county GIS website are proof that it's in violation of the setback. Then that would trigger the 5 years. However, I think it's important to note the pictures that appellants have submitted were done in 2019. So if those are the pictures proving in the public record, well, we haven't got 5 years from there. And again, that GIS is not a survey. GIS is a topographical picture, and the county uses the information they have to give approximate boundary lines. It says, if you look on the site under the photos, there's a disclaimer as to the accuracy. So we would say that the 5 years is not applicable, and if it is, it became applicable in April of 2018 when that survey. Same concept for
all of these buildings were in plain view from the road. Is that correct?
Your Honor, once built, yes, from Stinson Hardis Road, you can see down the driveway. Again, but just because you can see the garage doesn't mean you know where the boundary line. There's not flags, there's not survey markers there constantly until a survey is done or you walk out there and roll it out. You have no way of knowing whether it's 7 feet or 50 feet. It's not per the statute, it cannot be apparent without that survey. I think the statute is anticipating that you're zoned residential and you have an auto shop back there, and you can certainly look and tell, oh, that's a mechanic shop. That's not a home. It's different here. The facts are just different because I can't, with my own eyes, go stand on a road 30 feet away from a garage and say, I think that's 15 feet instead of 5. That's the county's argument here, is that the survey, which the appellants again didn't mention, the survey is what brought all of this to a head. The survey is what showed the setback violation. The survey was the first thing where you could see this is the building line and this is where the house was built. That survey is the first time that happened. And so, Your Honor, we would say the statute, one, doesn't run, but if it does run, it would be from April 2018. I see that my time is done. Thank you. We request you affirm the Superior Court.
Any other questions? All right. Okay. Thank you. And we're rebuttal.
Thank you, Your Honor. I will be brief. The county takes great pain to say that none of its officials, whether they were electrical or what have you, could have put the zoning folk on notice of this violation after they had been there, because they could not with their naked eyes see an encroachment or a violation. the findings of fact, or the letter sent to the Thomsons on page 100 and 101 of the record, say to them that there was the encroachment, and it goes on to say that a portion of the principal residential structure is located in the 20-foot side yard setback. They say they can't determine the exact date the encroachment first occurred. And then they say that the accessory detached garage is determined by its overall height because of its location in the rear yard. The existing garage is around 22 feet in height, which would require 15-yard side yard setback from the right-of-way. Now, the right-of-way is this private gravel street going right by there. Ms. McBride told you that this garage was 5 feet into, excuse me, that right-of-way. I cannot see how the county can now come here and tell you that with their naked eye, they couldn't tell that. The right-of-way is fairly clear. If you want to talk about side yard setback, maybe they wouldn't know the exact footage on that, but they sent people out to both of these buildings, and they may not be zoning folk, but I don't think that it's a stretch of anybody's imagination that when one department sees a violation, they have the authority to notice that and to pass that information along. For 14 years, this property existed without causing a problem to anybody. There's no evidence in this record that it obstructed the traffic and the flow in that right-of-way. In fact, the testimony in this record is that one of the adjoining landowners was willing to have it moved over. The only concern that the other primary landowner had on the back was he just didn't know how changing that right-of-way, the size of that right-of-way, might affect his ability to sell his property in the future. So no one complained that they didn't have proper access to their properties because of the way this garage or the house was situated. There's none of that. There was no complaint of that in the record. So we say that it is inappropriate to now bring this action against this owner and cause them to have to engage in an expensive undertaking. I think to remove a part of the structure of this main house would, in essence, be saying you need to rebuild this house, and to reduce the height of the garage, as the county has suggested it might do, by 10 feet or 15 feet off of this 22 feet high garage, and reduce the size back some, basically means you tear down this garage. It would not continue to exist as it is now. That's an unjust result, and we ask that you reverse the decision of the Superior Court. And I thank you for your time.
All right. Thank you very much for your arguments. And this session is concluded.
Goodbye.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you.
Thank you.